Hello and welcome to West Virginia versus EPA, the EPA's Climate Authority. My name is Chandler Randall and I am the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to today's webinar. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it is such an honor to have you join us today for this special program. Throughout today's webinar, we will be taking your questions, so please submit your questions through GoTo's question box, and please do not wait until the end. Send us your questions as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their expertise to this webinar. And while they will be introduced briefly, the full speaker bios are posted on our website, eli.org, and I encourage you to check out their expertise and experience in more detail there. As we begin, I would like to briefly introduce today's moderator, Michael Gerard. Professor Gerard is widely regarded as one of the leading environmental lawyers in the US. He is the Andrew Sabin Professor of Professional Practice at Columbia Law School, where he teaches courses on environmental and energy law and directs the Sabin Center for Climate Change Law. He served as chair of the faculty of Columbia's Earth Institute from 2015 to 2018. Before joining the Columbia faculty, he practiced environmental law in New York City for nearly 3 decades, most recently as partner in charge of the New York office of Arnold and Porter. Professor Gerard formerly chaired the American Bar Association's section of Environment, Energy, and Resources. He has served as a member of the executive committees of the boards of ELI and the American College of Environmental Lawyers. He is author or editor of numerous books and most recently publishing Legal Pathways to Deep Decarbonization in 2019. Thank you all so much. And with that, I will turn things over to our amazing moderator, Professor Gerard. Thank you all so much.
Chandler, thank you for that very kind introduction. I'm very pleased to be joined by Joanne Spaulding of the Sierra Club, Jill Tauber of Earth Justice, and Keith Matthews of Wiley Rhine. I'll say a few more words about each of them in a few minutes, but first I want to give a bit of background about the case we're discussing. And I'm hearing a lot of noise in the background, so if people can mute themselves, that'd be great. So in 2015, EPA issued a set of regulations called the Clean Power Plan. It was designed to reduce greenhouse gas emissions from electric power plants, mostly by reducing the use of coal. This reduction is essential if we're going to meet our climate targets. The Clean Power Plan required each state to come up with a plan to reduce these emissions, and that would usually involve not only making the power plants themselves more efficient, but also changing the mix of fuels used, procuring renewable energy, allowing emissions trading, and other actions. The Clean Power Plan was immediately met with a barrage of litigation. The main argument was that in various ways, EPA was exceeding the authority that Congress had given it under the Clean Air Act in issuing the regulations. The cases went to the DC Circuit, which refused to stay the rules, and the DC Circuit set up a briefing schedule. But in February of 2016, before the briefs were due, the US Supreme Court surprised just about everyone and issued a stay that blocked the plan so long as the litigation was proceeding. This was by a vote of 5 to 4. And no explanatory opinion was issued. The DC Circuit heard argument in September of 2016, but then in November, Donald Trump was elected president. He had promised during his campaign to repeal the Clean Power Plan, and after he took office, EPA did repeal the Clean Power Plan, and it issued a new set of regulations called the Affordable Clean Energy Rule. The challenge to the Clean Power Plan became moot, and the DC Circuit never issued a decision on that case. The Affordable Clean Energy Rule was also challenged in court, and on January 19th, 2021, the day before President Trump left office, the DC Circuit issued a decision in a case called American Lung Association versus EPA. The court ruled that the Affordable Clean Energy Rule and the repeal of the Clean Power Plan were invalid because EPA under President Trump was relying on an overly narrow construction of the relevant Clean Air Act provision. After President Biden took office, EPA indicated that it was not going to reinstate the Clean Power Plan. Instead, it was going to come up with a new set of measures to reduce power plant emissions. While EPA was at work developing the new measures, the Supreme Court surprised everyone again by agreeing to review the January 21 decision from the DC Circuit. The Supreme Court accepted 4 of the petitions for certiorari that had been filed, those from the state of West Virginia, the state of North Dakota, Westmoreland Mining Holdings, and the North American Coal Corporation. These cases were consolidated, and the Supreme Court heard arguments yesterday. So let me now introduce our panelists. Joanne Spaulding is Sierra Club's acting director and chief climate counsel, acting legal director and chief climate counsel. She oversees the Sierra Club's litigation campaigns nationwide, including managing the organization's federal and state climate litigation and regulatory work. She's lead counsel for the Sierra Club in the litigation arising from the Clean Power Plan and the Affordable Clean Energy Rule. Joanne previously worked at Adams Broadwell, representing labor unions in environmental cases. She received her BA from Northwestern University and her JD from the University of California's Hastings College of Law, and she clerked for the Honorable Melvin Brunetti of the Ninth Circuit. Jill Tauber is the Vice President of Litigation for Climate and Energy at Earth Justice. She leads the organization's litigation and legal advocacy to achieve 100% clean energy and to curb climate change. Prior to joining Earth Justice in August of 2013, Jill was a senior attorney at the Southern Environmental Law Center, where she led the organization's energy efficiency practice across the Southeast. Jill completed a Skadden Fellowship at the Advancement Project, a national civil rights organization, and served as law clerk to the Honorable Richard Paez of the Ninth Circuit. Jill received her BS from Cornell and her law degree from Harvard Law School. Keith Matthews has practiced environmental law for over 25 years. He's practiced in the private sector and for over 13 years was a staff attorney and assistant general counsel in the Office of General Counsel of the US EPA, first in the Air and Radiation Law Office, and then in the Pesticides and Toxic Substances Law Office. He's also served for 4 years as director of the Biopesticides and Pollution Prevention Division in EPA's Office of Pesticide Programs. As of counsel with Wiley Ryan LLP, Keith's practice focuses on the regulation of chemical products and ag biotech, including genetically engineered organisms regulated by EPA and the US Department of Agriculture. I'm going to pose a series of questions and invite the panelists to respond. We'll try to leave time for questions from the audience, and as Chandler said at the outset, you can type the questions into the questions box on your screen, and I'll read some of the questions at the end. So here's my first question. Elizabeth Preligar, the Solicitor General, represented EPA yesterday. She argued that the Supreme Court should not have taken the case at all because there is no regulation pending. The Affordable Clean Energy Rule is gone, and the Clean Power Plan has not been reinstated, and those rules have not yet been replaced, so there's nothing to review. And all the Supreme Court could do was issue an advisory opinion, which they're not supposed to do. That was the argument from EPA. There was quite a bit of discussion about whether the DC Circuit had revived the Clean Power Plan. Joanne and Jill, what do you make of the arguments on this issue yesterday and the questions that the justices asked about those?
Thanks, Michael. I think that the Solicitor General's argument was right on target. The DC Circuit opinion did not revive the Clean Power Plan because the litigants did not ask the court to do that. They didn't ask, in fact, they explicitly, the petitioners challenging the ACE rule and the Clean Power Plan repeal explicitly said in their briefs we do not want you to reinstate the Clean Power Plan. It wouldn't be appropriate at this point. The rule is, the deadlines have passed. The emissions targets are no longer relevant because the industry has already achieved the 2030 goals back in 2019. And in these circumstances, citing the small refiner lead phase down case, the petitioners argued that the better course is to vacate the unlawful replacement rule and to remand to EPA without reinstating the Clean Power Plan. So the DC Circuit opinion needs to be read in light of that, and it is and it doesn't explicitly say anything about reinstating the Clean Power Plan. In addition to that, and I think maybe Jill could talk about this as well, there are many reasons. The Clean Power Plan is not self-executing, so even if it were in place, it would require further rulemaking. And Jill, maybe you could take it from there.
Yeah, thanks, Joanne. That's exactly right. I thought the Solicitor General had excellent answers on this point. And in terms of the Clean Power Plan not being self-executing, there was a lot of dialogue, in particular with Justice Breyer and the litigants on this point of what did the DC Circuit do? What happens now? And I mean, the reality is, one, Clean Power Plan never took effect, right? That's clear. And two, as the Solicitor General pointed out, the deadlines that were in that original Clean Power Plan that was challenged have passed. The emissions targets have been met of the original plan because of market forces and the changing nature of the industry right now. It's obsolete. And so, and of course, EPA has said it's committed to writing a new rule. No litigant has asked them in challenging it to preserve it. So we have moved on from the Clean Power Plan. This case was not about the Clean Power Plan and reviving that plan, and it would not be revived with a decision here. And it's not, as Joanne said, I think it's really important to understand the nature of how 111D works. This is not a self-executing regulation that goes back into effect and sets emission standards. States would have to come up with a plan in response to the guidance that EPA puts out. So we're in a different place, a different space, and EPA, I know, is working now on new regulations.
Can I just add one more point? Not only is it not self-executing, but were EPA to begin to try to implement it, any action it would take would be petitioners would be able to challenge that action itself, and they would be able to bring another action challenging the underlying Clean Power Plan. That underlying litigation has been dismissed as moot. But they could use the after arising grounds provision in the Clean Air Act, and it's Section 307D of the Clean Air Act includes a provision that if there are grounds arising after the finalization of a rule at any point, then you can go and challenge that rule. So they would be able to use that by saying EPA said they weren't going to implement this. It has never been in place. They're now putting it in place. That's an after arising ground, and we can challenge it. And so that's why there's adequate legal remedy if for any reason this Clean Power Plan would bring back in place. And so any attempt, any ruling by this court on the Clean Power Plan or this case in general would be an advisory opinion.
So during the argument yesterday, the Solicitor General said that EPA would be issuing an advance notice would be issuing a proposed rule by the end of this calendar year and would be issuing the final rule a year later. But the Supreme Court, we expect, will rule this May or June. So Keith, I wanted to ask you, is there any procedural device by which the EPA could move more quickly in a way that would clarify the status of the Clean Power Plan?
Yeah, I think there's a potential option that might be available to EPA. And before I get into that, I'll make 2 points. The first point is I think Jill and Joanne, had excellent responses to the overall question in general. And I think that, everything that they said is actually spot on. And the second point I'll make is that I think the Solicitor General was a little bit optimistic in terms of her understanding of the rulemaking process. It's not often that you go from a proposal rather, close of a proposal, close of a comment period to a final rule in a year or less, particularly a rule that is very complex and for which the agency might in fact have a voluminous number of comments. But being optimistic is not to say that's impossible. It's possible, but I would say not likely. Be that as it may, with respect to your actual question, I would suggest that there is a regulatory instrument that if EPA found itself in a position where for whatever reason the Clean Power Plan has arisen from the dead and is now bears some semblance of existence there, and the agency wanted to formally close it out, it could use an administrative instrument called a direct final rule. And direct final rules were actually implemented first. They're pioneered by EPA, and they were initially used in the context of a situation where you have a situation that the agency needs to promulgate a rule completely non-controversial. The agency doesn't expect any comments on this particular action. And so what the agency would do is it would publish simultaneously a final rule that basically purports to implement the action within a certain time frame. And at the same time, it would publish a proposed rule in which it would explain, why it thinks that there's the rule is non-controversial and solicit comments. And what the final rule would say is that we've published this proposed rule simultaneously. We don't expect to get any comments. If we don't receive any comments, then we are going to go forward in this time frame. The time frame is set forth in the direct final rule, and we'll implement the rule as it is written here. And so that's a very convenient way to kind of get around the what can quite frankly be an excruciatingly long time period for doing a rulemaking under the Administrative Procedure Act as it has evolved to this day. Now, subsequently, after the agency got kind of comfortable with that, and in fact, I was instrumental in a number of instances where rather than say the final rule will go final if we don't receive any comments, I actually had a couple of direct final rules where I basically specified these are the comments that we are interested in. If we don't receive comments that specifically negate these conclusions, we're going to go forward. So that's a little bit of an evolution of the direct final rule as it initially been pioneered by EPA. And I would say the agency could do that here if it chose that, this is the Clean Power Plan somehow, as I say, rose from the dead and we're there as a specter. The agency could simply say, listen, this is moot. It serves no purpose. To the extent that we, as a matter of administrative law, need to formally revoke this or put it out of its misery, we're going to do so with this instrument. We'll take comment on it, but that comment, I would suggest that the comment should be directed to specifically persuade the agency that there is a reason to keep the Clean Power, the CPP in effect. And if the comment doesn't do that effectively, the direct final rule goes forward.
So what would be the timing of that? I mean, would it be like a 30-day comment period and then EPA act fairly quickly after that?
Yeah, the agency could do it. I mean, you could write it in. Quite frankly, I think given the expertise that's in the Office of Air and Radiation, they could probably write that in a month to a month and a half. Take a 30-day comment period and say it's going to be implemented in 15 to 30 days based upon the comments they received or not received. So it could actually be very quickly.
Joanne and Jill, do you have any thoughts on that?
Yeah, I think that EPA has not taken that step because it hasn't perceived it to be necessary. because and I think, Keith, I think this goes to what you were saying, that this would essentially be well, to the extent that it is necessary to do this, then we are just here confirming that the Clean Power Plan is not in effect, has never been in effect, and this is just confirmation of that. I do wonder to the extent to which some of the justices might have frustration with EPA at maybe somehow trying to deprive the court of jurisdiction to hear this case. I don't think that's a legitimate concern, because the court, I don't believe the court has jurisdiction to hear this case. I think it would be an exercise of judicial activism to reach out and issue an advisory opinion in this context. But there is, I have heard that concern.
Yeah, I would just jump in to say, I agree that I don't think EPA perceives the need to do that. And although it's an interesting idea, and I'm learning here from you, Keith, I think, what was clear from the argument was EPA's, from the Solicitor General, their expression of what their plan is. We are working on the rule now. We are going to have a notice of proposed rulemaking out by the end of the year. Usually the time frame I think the Solicitor General gave was we expect a final rule a year after that, and they are, the agency is working right now on it. There is no rule on the books. CPP is not in existence, and they're sort of doing what they need to do to get a 111D standard set. So I think that's where their focus and energy is, and that's what they represented to the court.
Yeah, Michael, a couple of points just to follow up. Yeah, I wasn't, just want to make clear, I wasn't suggesting that EPA either needs to do that or should do that. I was just answering Michael's question. Is there something out there that they could do if in fact it were deemed to be necessary? And then the second thing I'll say is that there is a little bit of danger there because to my knowledge, a direct final rule has never been challenged. And so, as I said, EPA pioneered this. I think other agencies have used this. I think as a matter of administrative law that it meets all the requirements of the Administrative Procedure Act, but it is a bit different from the normal rulemaking. And so I do think agencies need to be careful to not go out on a limb on this, because you really don't want to be in a situation where a court comes out and says, no, I don't know where you guys got this from. You shouldn't be doing this. Don't ever do it again. Because quite frankly, in the context of a non-controversial situation where the agency just wants to get something done quickly and cleanly, it actually is a very useful instrument. So you don't want to overuse it and put it at risk.
And if EPA were to do it, probably the first court we would hear talk about it would be the Supreme Court, deciding in this case whether or not they thought that was valid, whether they thought that was an effective action by EPA in closing the door on the Clean Power Plan. So it's entirely possible that the Supreme Court will get to the merits, that they'll conclude that they're not being asked to issue an advisory opinion, but they really want to rule. And of course, that the merits are mostly about Section 111 of the Clean Air Act, and a lot of that has to do with whether the sort of measures called for in the Clean Power Plan fit within the best system of emission reduction, which is what 111 is talking about. So I'd like to invite you to talk about what you heard in the oral argument on this issue, on the merits of 111 and what you think of it. Who wants to start?
I can start. Thanks, Michael. So it was interesting that, and heartening, that nobody here is challenging the court's ruling in Massachusetts versus EPA that it is, EPA has the authority and obligation to regulate greenhouse gases under the Clean Air Act. There was not a lot of discussion about the Supreme Court's decision in AEP versus Connecticut, in which the court said that EPA is the expert agency, and it is the agency with the expertise to establish standards for greenhouse gas emissions from this source category, fossil fuel fired power plants under the Clean Air Act. The question here was all about the way that EPA decides to set these standards, what it looks at, what the statute instructs EPA to look at the best system of emissions reduction that has been adequately demonstrated. And so that calls for an inquiry into the source category and the kind of pollutant and the nature of that pollutant. And so with this particular source category, the question, this inside the fence versus outside the fence line question at issue is can EPA only require reductions at the plant itself, and those tend to be bolt-on emissions control technologies or improving the efficiency, or can it go beyond that, look to the source category as a whole, and look at how do you get reductions from this source category? And in this case, the electric sector is unique. There is no other source category that is integrated that the way that power plants are. They are all part of a bigger system. They're all interconnected. And so reducing power generation at one plant requires an increase at another plant to meet the needs and vice versa. And so this question in this context is essentially, can EPA look at this source category and see the how it operates in the real world and at this pollutant and say, okay, this is a global pollutant, reductions in one place it's essentially fungible, both in terms of the product and the pollutant. And so that's what EPA did. And so I just think it's really important because the petitioners in this case seem to think that, oh, once EPA does this, then the cat's out of the bag and it's going to apply to all these other source categories. It's not. This one's unique. And I think that came across in some of the questioning by the court that I thought was quite interesting, was the observation that the stringency of the best system of emission reduction and the performance standard that arises from it isn't necessarily related. It's orthogonal to the, and that's a quote from Beth Brinkman, by the way, to the question. The stringency is orthogonal to the question of whether it's inside the fence line or outside the fence line, whether it's to or at the source or for the source. Because you can have a very weak rule, as the ACE rule is, based on inside the fence line, but you could also have a much more stringent rule, because EPA in the ACE rule essentially didn't even set a standard or indicate what a standard could be. They just said, here's a list of control measures, efficiency measures, and we're not going to even look at really the two most effective measures, because we think, oh, nobody's going to want to do those because they're too expensive and they're going to trigger other permitting requirements, which is completely beside the point, by the way. And so it's an incredibly weak rule. But you could also see a really weak rule that would be outside the fence line, that would say, oh, we're just going to require a little bit of generation shifting. And the justices, at least some of the justices, really perceive that difference. And I'll stop because I've been talking a lot.
Let me just say one word for the people who haven't delved into Section 111. Section 111 requires EPA to designate certain source categories. The relevant one here is fossil fuel power plants. And the question, a major question is system referring to an individual power plant, or is it referring to the grid of which individual power plants are a part? So if you're talking about the system, it increases the scope of things that might be done to reduce the emissions.
I'll just add, you know, the argument got into this right off the bat with Justice Thomas asking whether you needed the major questions doctrine in this case, and this was to General C for petitioners, and the answer was no. And then there was a dive right into the text, and I mean, I do, you know, some of this does come down to that understanding of systems, which is in the statute. What's not in the statute is at the plant. So there's a real strong plain language argument here. I was also struck by the exchange around this inside and outside the fence line distinction, and I believe it was Justice Kagan who said it's something to the effect of it's not necessarily relational to strong or weak or big or small impact. And I think that's really important if you're understanding the petitioner's argument about this being all about whether it's inside or outside the fence line. The other thing I would add is the discussion, if you're looking again at the text of the statute, and in particular 111A1, there were questions about what are the guardrails, what are the limits on that, and that's also clearly in the statute with respect to considering whether it's adequately demonstrated. So is this happening, right? And there was a good discussion, certainly great discussion in the briefs, and discussion at the argument about how this power generation thing works, right? How does the grid work? And are these different tools that the Clean Power Plan contemplated, at least as reflected in the best systems of emissions reductions, is that happening? And the answer is yes. And that's part of the reason why we are 10 years ahead of accomplishing the goals. But the statute also speaks to costs, reliability of the grid, all those factors that are in the statute to provide limits as to what can be included in the best system of emissions reductions. And I thought that was a good exchange and argument.
I mean, one thing that became clear in the argument is that several of the justices at least thought that this was anything but a sharp distinction between inside the fence line and outside the fence line. Most of the prior discussion suggested it was a sharp dividing line, but it was pointed out, for example, that the EPA could impose really severe limitations entirely within the fence line. They could tell coal-fired power plants they had to shut down, or they had to retrofit with carbon capture and sequestration, which would not be economically feasible under any calculation to retrofit. But it was quite interesting to see that previously envisioned sharp distinction kind of fall away. One of the things that some of the justices seem to be concerned about, and Jill alluded to, is that what are the guardrails? What are the outer limits of EPA's permissible regulation here? And that issue, of course, was important in the Utility Air Regulatory Group case, the 2014 decision that concerned a different program under the Clean Air Act, the New Source Review Program. And in that case, the EPA had said that the numerical numerical numbers, the requirements for what size of emission source requires a permit are way too low when it comes to carbon dioxide. If it's 25 pounds per year or something like that, that may be okay. Tons per year, that may be okay for sulfur dioxide and conventional air pollutants, but it's way too small for carbon dioxide. That if you regulate carbon dioxide sources that emit that little, you're going to be regulating hundreds of thousands or maybe millions of sources, and EPA didn't want to do that. And so EPA instead issued a tailoring rule, a rule that greatly increased the threshold so that it could regulate many fewer sources. But the majority opinion by Justice Scalia said EPA wants to have the authority to regulate these hundreds of thousands of sources, and that's going way too far, and said that the tailoring rule, this effort to reduce the number of sources regulated, represented exceeding the authority of the EPA. So this issue of what are the guardrails, how far can EPA go under the Clean Air Act, was something that I think some of the justices were interested in. Any comments on whether there are guardrails here, whether there are limitations on how far EPA can go, or whether that's necessary, or is it that what matters is how far EPA really wants to go, or how far is EPA trying to go, as opposed to how far could it theoretically go?
So I think Jill started to set those out, but they are, first of all, the system of emission reduction has to be adequately demonstrated. And I think the power companies' briefs and Beth Brinkman in the argument really conveyed to the court, this is what we do. And there are also there's amicus brief from grid operators explaining, and you could tell that the court had become familiarized itself, or at least most of the justices had become familiar with, here's how this system operates. And so that's adequately demonstrated is important. The costs, the statute also requires the EPA to take cost into consideration. And as I can't remember which council pointed out, that this is not a balancing, this is not the cost benefit analysis that EPA does as pursuant to that executive order that requires them to do a cost benefit analysis. This is an analysis of the impact of the cost on the industry. And so that is a guardrail, because EPA cannot impose a rule that would have such dramatic impact on the industry that it would I will say EPA can impose a rule that which some plants would shut down. And that there's precedent that explicitly says that, and Congress contemplated that. You can look at the legislative history of the Clean Air Act. It contemplated that sources would become obsolete, that facilities, that new technologies would evolve, and that older polluting sources would eventually close. And it's a technology forcing statute. So it's fine for some sources to shut down, but it's not fine for EPA to impose a standard that would be disruptive to the entire industry and be more than the industry could bear in terms of costs. And and then there's an energy requirement in the statute. EPA has to consider energy. So they can't, and threaten reliability. They have to look at, and the statute explicitly tells EPA, look at the energy impacts of your decision. So those are, I think, really serious and meaningful guardrails.
And I think it's worth emphasizing, I don't think we can say this enough, this is happening. You have to look at the power sector. I mean, it's striking to have, the power sector is there arguing in favor of EPA authority here to provide this regulation, and its authority to provide regulation. And I think that reflects the reality of the industry right now, of what we're seeing in the power sector space. We are seeing a transition away from dirty resources. We are seeing a scaling up of renewables. That's what's happening. And by the way, I don't think it's lost on any of us and of the people in the audience that timing of yesterday's argument coinciding with the release of the IPCC report, for good reason, we have to transition. So I just think this, a lot of this argument yesterday was in the abstract, in part because there is no regulation in place right now. So that's sort of inherent in this, and of course implicates all the justiciability questions, but we have to look at what's happening, which is this is an industry that is transitioning in the face of evolving technologies, in the face of plummeting costs of renewables, and I just think that's in the background and was effectively also conveyed at yesterday's argument.
Let me just remind the audience that if you have any questions you'd like to please put them in the question box that you see on your screen. Jill mentioned Massachusetts versus EPA, and one of the concerns that some people had before the argument is that the court might take this as an opportunity to undo parts of that seminal case, the case that said that EPA does have the authority under the Clean Air Act to regulate greenhouse gases. In view of the very minor discussion of that case yesterday, are you now feeling better, less worried that Massachusetts parts of it might be overturned?
I mean, I can jump in just to say it was briefly discussed yesterday, and I think the discussion amounted to, are you challenging Mass v. EPA? Answer no. And are you challenging AEP? Maybe a little less. No, not challenging the idea that EPA can regulate greenhouse gas emissions from power plants. So those core holdings, which of course are the law, I felt good about them going in, and there wasn't a lot of focus on them at argument, I think for good reason, because it is so clearly the law and within EPA's authority to regulate.
Now, of course, part of the American Electric Power case primarily was about saying that the federal common law of nuisance was displaced as to greenhouse gas emissions because EPA had the authority to regulate greenhouse gas emissions, especially as affirmed by the Massachusetts case. There was also a statement in the AEP case that Section 111D was available to EPA to regulate sources, and I didn't hear a clear affirmation from the petitioners that they still believe that that part of the AEP decision was still valid, but we'll see how that comes out.
So I actually, I didn't hear it that way. I thought that they did, because I think the holding of AEP versus Connecticut depends on Section 111D, because that is the provision that addresses emissions from existing power plants. 111B is the new source standard, and that's not what that case was about. It was really explicitly about whether 111D displaces federal common law. And so it just would not make any sense to read that case in any other way. And I think that the petitioners in this case conceded that. It was a question of, well, just because EPA is the expert agency and it has this authority under 111D, it doesn't have the authority to do this cap and trade program, this broad program that is really regulating the electric sector and the grid and not regulating pollutants. And that was really where their dispute falls. Now, of course, what EPA is doing is regulating pollutants. So, from my perspective, I think that's what EPA would say and has said. So, but I think that the concession about AEP versus Connecticut that petitioners made at oral argument is important because it is essentially an acknowledgement of the role of 111D.
And so the big question is, what is the scope of 111D? How far can EPA go? And did EPA go too far in the Clean Power Plan, or was it more restricted? Joanne, you mentioned cap and trade, and there was some discussion of cap and trade in the argument yesterday, but there's also been some commentary that some of the justices may have misinterpreted the role that cap and trade played with the Clean Power Plan and its relationship to prior legislative attempts, such as the Waxman-Markey bill of 2009, which would have been a cap and trade bill, but was never enacted. Any thoughts on that?
Yes, I thought that was a very important point. That there's been throughout this litigation this effort by the West Virginia and its the states aligned with it, and the coal industry private parties that what EPA is trying to do something that Congress tried to do and didn't. So therefore, that's somehow means that EPA doesn't have authority to do it. But EPA, first of all, legislation that was never enacted should never be relied upon to interpret a statute that was enacted. It's pretty basic in terms of statutory interpretation. But they are also, the point was made that they are also completely different kinds of provisions, because this is just within the electric sector. It is just the sources that are subject to regulation under the Clean Air Act that would be subject to this standard. And in that context, there are trading schemes that are in the Clean Air Act that Congress has has included explicitly and blessed. And so again, Beth Brinkman's point, representing the power companies, was that because they're there, because that's one of the systems that's adequately demonstrated. And it doesn't have to be explicitly mentioned in 111D because it's on the menu. So, but it's fundamentally different than an economy-wide cap and trade program.
Right. Waxman Markey would have established a mandatory economy-wide cap and trade program. The Clean Power Plan did not. It provided that trading was an option that could be used. It was an additional flexibility mechanism that would allow the power industry to reduce its overall costs in achieving the requirements. And as was pointed out yesterday, the text of 111D says that states are to come up with plans like those of Section 110. Section 110 is the section that calls on states to prepare state implementation plans to achieve the national ambient air quality standards. But Section 110 explicitly says that market-based mechanisms, such as cap and trade, are a permissible element of a state implementation plan under Section 110. So there was also some discussion yesterday about whether the reference in 111D to Section 110 was just about the procedural parts, the part that each state has to come up with its own plan, or whether it also included the substantive part, such as the allowance of market-based mechanisms. Was there anything else? I'm going to turn to the major questions doctrine in a minute, but before we get to that, was there anything else about the Clean Air Act that came up in the discussion yesterday that any of you want to comment on? Okay.
Mike, the one thing I would just say is that there's what you just mentioned reminded me of the roles of EPA versus the role of the states. And I think that in the context of 111D, and the Clean Air Act, of course, as we know, is a cooperative federalism statute. So it has roles for the federal government and the state governments. And what EPA does in this context with existing sources, rather than set a standard of performance that directly applies to the regulated sources, it sets a benchmark. It's essentially a benchmark that states then have to apply to the sources within that state. And nothing about the Clean Power Plan, to the extent that's even something that the court should be considering, because it's not what's being appealed. But nothing in that took away the states still had the ability to do that. And that is it's a fundamental feature of Section 111D, that the states then apply the standard that the benchmark that EPA establishes. And so there was this inconsistent position, I think, because under the ACE rule, EPA said, well, you can't go outside the fence line, and EPA is not doing that in setting the best system of emissions reduction, and states and power companies cannot go outside the fence line in applying that. Now, I actually think that that's right, that there has to be symmetry, because if EPA can't consider certain mechanisms that the states and power companies would use to comply, then they might be establishing a weaker rule than they otherwise would. But what the power companies seem to be saying is, oh, no, even though the ACE rule said that, really states could fudge it in the implementation and enforcement. And so I think it's just a fundamental inconsistency that draws attention to the disconnect between the inside and outside the fence line dynamic or opposition.
I mean, I think one thing that is very important for people to understand is most of Section 111 is about new sources of air pollution. And for the new sources of air pollution, EPA can impose direct standards. They can specify the technologies or the emissions that the new sources can emit. But 111D is this little exception that applies to existing sources. And for the existing sources, EPA has a whole lot less direct authority. There are restrictions on what kind of sources can be regulated under 111D, and if you're one of those kinds of sources, as you've been saying, it's to the states to come up with the implementation method. And one of the arguments against the Clean Power Plan was that EPA was too prescriptive in what it told the states to do, that the states, in reality, had fewer options to achieve that. But still, it's the states that were in the on the front line. Keith, let me ask you, we've been talking generally about how the court has been approaching the statute and the timing of this litigation and so forth. And I wanted to ask you if you have any observations on the effect that these issues would have on administrative law more generally, or on other agencies, or the way courts approach administrative actions.
Yeah, thanks. Actually, I do. And before I start, just to set some context for folks who may not know me. So I will say that I find this discussion to be very interesting and, quite frankly, very enjoyable. It takes me back many years to these sorts of discussions, very detailed discussions of the Clean Air Act that were being held in Arlo, and back when I was in OGC at the beginning of my tenure in OGC. When Chandler called me up and said, you know, we'd like you to, ELI would like for me to be a part of this panel, I said, well, you do understand I'm not a Clean Air Act lawyer. I was in Arlo for some time, but when I was in Arlo, the Air and Radiation Law Office at that time, I was in fact the R. I used to refer to myself as the R in Arlo. I was a radiation attorney, so I counseled the Office of Radiation and Indoor Air on radiation protection standards that apply to nuclear waste disposal facilities. But I was part of the law office, and I sat in many times on discussions that were being held, very detailed discussions on, you know, very particular provisions of the Clean Air Act. And, you know, I kind of, you know, harken back, my memory harkens back to, you know, listening to experts like Alan Eckert and Rich Osias, you know, Mike Thrift, Jeff Wilcox, you know, talking about these things, people who know the Clean Air Act probably better than anybody else in the world. And so, but moving on from that, I did move on from that. And so, you know, became a chemicals regulation lawyer, you know, focusing primarily on ag chemicals and ag biotech. And from that standpoint, that's one reason why this case was of significant concern to me, because, you know, I was, and I still am, I mean, obviously we just had oral argument yesterday, the court hasn't issued opinion, no one has any idea what the court's opinion is going to be. I mean, it's really, you know, all well and good to sit here and do, you know, Friday morning quarterbacking, you know, and kind of figure out what's the you know, what's the opinion going to look at based upon, you know, what we've seen. But, you know, the court hasn't even taken this into chambers yet. So, you know, it will be interesting to see how it comes out. And as you know, mentioned, for someone such as myself, you know, this whole concept that seems to have developed or be developing. I mean, one of the things I found interesting about and there was a fair amount of discussion about major questions yesterday, but to my way of thinking, it doesn't seem to me as if this is really a fully fleshed out concept. There seem to be a fair number of questions. Well, what is a major question? Well, is this a major question, or how do we get to a major question? Or, you know, is it a clear statement versus a major question? You know, I mean, how does all of this play into the administrative law fabric, or the fabric of administrative law? And so I will say this: my practice is based really at the edge of technological development. You know, I work with companies that develop genetically engineered organisms that are regulated by the agencies. And so, you know, no one in their right mind thinks that genetic engineering, say ag biotech, that, genetic engineering of agricultural, either plants or animals, is far more genetically engineered plants that have been developed to date. But animals are coming. Insects are here. Animals are coming. Nobody in their right mind thinks that this enterprise should be unregulated. Obviously, that we need to have governmental oversight to ensure that there's safe, effective, and useful deployment of this technology. But there's also, when you look at it, I mean, from the ag biotech standpoint, you have EPA, FDA, and USDA. Well, do any of those agencies have explicit statutory authority to regulate genetically engineered organisms? I think that's an open question. Now, with respect to EPA, I think EPA probably has, very, very strong statutory basis in the pesticides context under FIFRA, because FIFRA authorizes EPA to regulate any substance or mixture of substances that is intended to prevent, destroy, repel, or mitigate a pest, or that alters the physiology of a plant. So if you are developing a genetically engineered organism that is intended to have an effect such that it prevents, repels, destroys, or mitigates a pest, I think, or that it alters the physiology of a plant, I think that you can say EPA probably has very strong statutory authority going forward. It didn't need any further direction from Congress to regulate these sorts of organisms. And the same, I think, would be true with respect to, say, genetically engineered insects, if they are being genetically engineered for a pesticidal purpose. So I'm not so concerned about the how administrative law may evolve in that context with respect to EPA's regulation of ag biotech. But as you note in your question, I mean, this is an issue that is far larger than just EPA. And so I think that we have to be very careful. We as a society have to be very careful, in going down the pathway of taking the position that, well, Congress has to have explicit delegation of authority to an agency for an agency to have regulatory authority over a particular, commercial aspect of commercial enterprise, because technology waits for nothing. It's actually fascinating to me at just how rapid technological development is occurring now. You look at, I was thinking about this yesterday. So take the 8th day of creation. Going from Gregor Mendel to Watson, Crick, and Franklin. That took 80 to 90 years. Well, you go from there to actual genetic transformation with transgenic organisms. That took 25 to 30 years. And now we're in the age of genome editing. Who knows what's going to come after genome editing, but I will guarantee you it will be something. Genetic engineering is not going to stop at genome editing. The ability of humans to alter genetic structures is not going to stop at genome editing. And at the end of the day, I worry that the administrative state is too ossified and moribund to effectively regulate developing technology. With the advent of the, we talked about it earlier, the Administrative Procedure Act, the way that, what agencies have to go through in order to promulgate regulations, I mean, it takes so long that there were times when I was at EPA where there were regulations that were being contemplated, and it would occur to me that, by the time we get through with this rulemaking, it's going to be obsolete. Because technology is going to will have moved on, and then what do? Well, I guess you start another rulemaking. Okay, that's fine. By the time we're ready to regulate what we now have before us, well, that's going to be obsolete as well. That new rulemaking is going to be obsolete. So then, given the fact that, the legislative state is something less than efficient now, it would occur to me that, it's even more time consuming and less effective to get legislative action than it is to get administrative action. So I think that we have to be very careful about going into a world where we think, where we want to pull back the authority that regulatory agencies have to regulate at the far ends of technology, when in fact health, safety, environmental, environmental parameters and concerns are paramount. We want to make sure that the technology that we are developing is a technology that benefits mankind, and looking at it from the FIFRA standpoint, does not have unreasonable adverse effects. So, obviously there are adverse effects to many sorts of advances, but we want to make sure that the benefits of technological development outweigh the potential adverse effects and potential detriments of it. And I'll stop there.
Thank you for that. I mean, of course, Congress has not passed a major new environmental law since 1990. They amended Toxic Substances Control Act in 2006, but otherwise it's been more than 30 years. And so if Congress has to 60, right? If Congress has to act very explicitly on new threats before administrative agencies can act, that's a real problem. We saw that arise just a few weeks ago in the OSHA vaccine case. So let me invite Joanne and Jill to comment on the discussion yesterday about the major questions doctrine. And again, I'm hearing noise in the background. If people could put on mute, but
yeah, I can jump in on that. A lot of discussion, not totally surprising, I suppose. And I think whatever you think about the doctrine, one thing that was clear is really hard to do an analysis when there's no rule in place, right? This is an abstract question as it was presented and discussed. I thought that was a pretty effective, compelling point that the Solicitor General for the government made. There were so many. It was quite striking. There were so many questions about what the doctrine is. Maybe just that precise question. What is it? What's the daylight between this and non-delegation? What is it again? How do we know, what is the what? That was a question by Justice Kagan as she described one piece of how she understands this doctrine to be sort of the agency's doing what? that sort of test of is it outside of its lane? And I don't know that I got a clear picture from the questions in terms of where the justices, a clear view emerging about the application of that doctrine to this rule of the abstract. I do think it gets into a bit, you're talking about major questions, so the ideas of part of the analysis, at least, is the magnitude of the impact, and that gets us to what we talked about earlier. The inside, the outside fence line distinction is not a proxy for major or not, right? That's not the way, that's not the reality of control measures that you can apply inside versus outside. It's not a non-major versus major question, so there's just no relationship there. And that was, of course, that's sort of a major line of argument. I'll just flag one interesting part of the argument that I thought, with respect to major questions in particular, was a discussion between the Chief Justice and the Solicitor General on sort of what goes first, the order of analysis. Do you first assess that there is an ambiguity in the statute? And if there is, maybe this is a way of sort of the next step of what you do with that ambiguity. You determine, is there sort of a sweeping effect here, or do you flip that order? And I think there's, that makes a big difference, and that was explored at least in some level of detail in that exchange, and I thought that was interesting. But here, I don't think major questions has a role in this case. It did get a lot of time during argument, though, so obviously hard to say what the opinion would say on that.
Joanne?
I found it interesting that both advocates for petitioners said we don't need the major questions doctrine in order for you to decide this case in our favor. You can just look at the statute itself. And so I'm not really sure what we're doing with the major questions doctrine. If that's their position, then, you know, and their briefs started with these long expositions of the major questions doctrine. And if you read those briefs, it's not clear that anyone has a clear understanding of or agrees with what the doctrine is and how it applies. And so, and I think that was reflected in the discussion at oral argument. There was this question, I mean, I think Jill went into detail about like, when do you apply it, to what do you apply it, and what kind of canon is it? Is it constitutional? Is it linguistic? Just as Barrett asked if it was a linguistic canon. And in terms of what you apply it to, Solicitor General C said, you know, that the source specific inside outside the fence line decision itself is not what the major question is. That's a statutory limit. And so I don't know what is the major question, because she said it isn't simply a matter of this particular exercise of agency power, but then what do you apply it to? Because they have already said EPA has the authority to exercise a regulatory power over this pollutant from these sources. So I thought it was really, there was just a lot of lack of clarity there. And I also thought that, you know, there's this whole question of, oh, is EPA doing this because Congress is so dysfunctional? And I don't really think you need to go there. EPA is doing this because it has the authority to do it and the obligation to do it in a statute that has been adopted, that Congress did enact, and that the Supreme Court already has interpreted. And should there be any doubt about that, you know, on the method with the EPA's methane regulations that apply to the oil and gas industry, Congress just recently, in the context of the Congressional Review Act, well, let me just back up. So the Trump administration repealed the methane regulations of the oil and gas industry, and in Congress there was something called the methane policy rule, and Congress said no. They repealed that methane policy rule, which essentially was saying EPA said we're not regulating greenhouse gases under Section 111, and Congress said no, you need to, and that was under 111B for new sources. Congress said no, because this is a predicate. First of all, you need to do this because the statute requires you to, and it's a predicate for existing source regulation. So we have a very recent statement by Congress that this is all appropriate. So it's just really unclear what this major questions discussion is all about and why it's necessary at all in this case. And just one more point is that, you know, there was this discussion in the oral argument about looking at the action, the regulatory action under review, and saying, is this surprising? Is it surprising that this agency would do this thing? And it's just clearly not surprising, given all that history, that EPA would be regulating greenhouse gases from the largest stationary source of category of greenhouse gases.
Right.
Hey, Michael?
Yeah.
Yeah, can I make just a very quick point? Just to build on what Joanne just said, I think that EPA, I would phrase it as EPA is doing this because Congress in 1990, 30 years ago, was not dysfunctional. I mean, can anyone imagine a legislative accomplishment such as the Clean Air Act amendments passing today? I mean, that's ludicrous. You can't even think about that. You know, it's like, well, when will pigs fly? You know, so you know there was authority that was given to EPA in 1990 that, you know, under no circumstances could happen now.
Yeah, I mean the issue, and this was, I think, the question Justice Kagan was asking, are you surprised that the agency is acting? So the Supreme Court was surprised when the Food and Drug Administration tried to regulate tobacco, and that was the Brown and Williamson case. I'm not sure that people should have been surprised when OSHA started regulating masks and vaccines, but in any event, they used the major questions doctrine there. But it was very interesting that Justice Thomas's very first question of Lindsay C., the lawyer for West Virginia, was, do you need the major questions doctrine to win? And she absolutely said no. She thought that the case could be decided on the statute. But the amount of airtime that the major questions doctrine received yesterday was very large, and we'll see if the court takes this as an opportunity to again use the major questions doctrine to more clearly define it, because as you said, there were several questions. Well, what exactly is the doctrine? What does it mean? How does it relate to non-delegation? We'll see. So there was a lot of attention in advance of the argument yesterday to the non-delegation doctrine, the idea that the Constitution gives sole legislative power to Congress, that administrative agencies shouldn't have too much discretion in setting policy, and it would be exceeding the constitutional power of Congress for it to delegate too much discretionary policy-making authority to agencies. Now, that's a doctrine that has only been used twice by the Supreme Court to invalidate congressional action. Both of them were 1935. But in some recent dissents and concurrences and so forth, several of the justices have expressed interest in the non-delegation doctrine. And there was a lot of concern that this case might be the opportunity for the Supreme Court to use that to swat back parts of the Clean Air Act itself, not just what EPA was doing. But it was quite interesting. There was very, very little discussion of the non-delegation doctrine yesterday. So do like to ask the panelists, do you think we no longer have to worry about that, at least in this case? Or I mean, it was interesting that Justices Gorsuch and Kavanaugh said very little yesterday. They had very few questions. They were sort of seen as among those leading the charge on the non-delegation doctrine. Do you have any thoughts on the sort of the relative absence of non-delegation discussion yesterday?
I just essentially agree with you, Michael, that it didn't look like that was anything that the advocates were pushing strongly, or that the court was very interested in. There were a couple of questions. There was the Solicitor General C said, well, we're looking at this as constitutional avoidance. You don't need to go to non-delegation because if Congress had delegated to EPA the authority to do the Clean Power Plan, that would implicate non-delegation, but they didn't delegate that authority because there's no clear statement was that her position. And of course, our position is the opposite, that that Congress did in fact delegate this authority, and it did so appropriately. But it didn't seem like, given the Massachusetts versus EPA and the AP versus Connecticut, that there was really any traction for the non-delegation argument.
I agree with that. It struck me that it was largely discussed in the context of trying to explain the major questions doctrine here and what that would look like by way of either comparison or sort of how it could relate to that. But I didn't hear much on its own. I think for good reason. I think this is clearly constitutional and within EPA's authority under the Clean Air Act, but agree with your sense of it not really taking up much airtime.
Yeah, and I'll just say that I hope that everyone is right. because I would just say in general, and this is completely consistent with what I was saying earlier, that I think that it would be very, very problematic if we have a situation where people believe that we have to hew, as originalists might want, that we have to hew too closely to the original intent of people who put together a document in 1789. In the year 2022, I would posit that the world has changed a bit since then, and that our system, how we look at things, how we look at governance, needs to evolve as well. And I'll leave it at that.
So I see a couple of questions have come in, but frankly, I'm having difficulty opening up the box. So Chandler, could I ask you to take a look at the questions, and if there's some questions that you think we ought to address, Chandler, if you're still on?
Yeah, absolutely. Let me take a look really quickly. Maybe we can ask another question really quickly while I'm looking.
I have a comment, Michael. If you, I just want to point out that based on what Keith just said about looking at the original intent, non-delegation was not a thing at the founding of this country. And there's a really great amicus brief in this case by Julian Davis Mortensen, who did a really in-depth historical analysis of the non-delegation issue. And so I just would really recommend that to folks if you're interested in that issue.
Yeah, there is some debate among constitutional scholars about that issue, and I think we may see that play out in some future litigation. But it doesn't look like this is the occasion that they're going to use. Okay, so I do see one question that I can read. How does this action by the Supreme Court influence thinking about Congress simply enacting a carbon tax? Seems much less subject to legal challenge. Any thoughts on that?
Well, I'll just say I don't think this, I think there is a lot that Congress can do. I would start with Build Back Better. I would start with the historic investments in climate and environmental justice that passed the House, that is unfortunately has not passed the Senate yet. So, I don't view these as, this is not a zero-sum game as between different branches of government. We need congressional action. There again, I would point to Build Back Better, and we need EPA to continue to use its full authority and really meet its obligation, its statutory obligation to cut pollution and protect our health.
Yeah, I mean, there's a lot. I absolutely agree with Jill. There's a lot that Congress could do if it wanted to, and it could do it in an unambiguous way that would clearly be within the power of Congress. And a carbon tax is one of those. Politically, that doesn't seem to be in the cards right now, given our 50-50 split in the Senate. I think, of course, tonight President Biden is giving a State of the Union address, and I think he's going to make another pitch for at least the climate-related portions of the Build Back Better Act. Congress could also resolve the ambiguity, if there is ambiguity in the Clean Air Act. There's a whole lot that Congress could do, but Congress seems to be paralyzed along these lines. Another question, if the court finds standing in this case, what's left of the Constitution's case and controversy clause?
Such a great question. I just, I guess there's an upside for environmental litigants because if they're standing here, I don't know how they're going to tell us we don't have standing in future cases. That's a little bit of a flip answer, but I think there's a lot of truth to it.
Yeah, if concerned that an agency might do something, might do something bad as a basis for standing, there are a lot of people who would have standing in that kind of instance. So it may just come down to the question of did the Clean Power Plan spring back to life in the American lung case? Did the fact that the DC Circuit said that EPA was misinterpreting the statute when it repealed the Clean Power Plan. Did that spring it back to life so that we can now challenge the Clean Power Plan, even though, as you've all pointed out, the Clean Power Plan is in every respect obsolete? You know, the objectives have been met, the deadlines have been passed. EPA doesn't want to put it back, but I think that it would have to be deemed to have sprung back in order for this really to be a case and controversy.
And even if it were somehow technically had sprung back into life, there's nothing imminent about the impact of it on any of the litigants in this case, because EPA would have to take further regulatory action to actually somehow implement it. And that would be subject to review, both in and of itself, and as I said before, by an after arising grounds lawsuit challenging the Clean Power Plan itself.
Another question. I was surprised by Justice Breyer's hostility to some of EPA's arguments in his question. Any reaction to that?
I'm not.
You're on mute, Jill.
Oh, sorry. I don't know that I heard hostility. I guess I would say I think there was what we were just talking about, the impact of the DC Circuit's decision and whether that somehow springs this back to life or not. There was a lot of sort of active exchange there. I think really in an effort to understand fully what, if anything, is in place now. The answer is nothing, and there was a lot of back and forth to get there. That's the one exchange, thinking about Justice Breyer, that stuck out to me, in addition, of course, to a salmon analogy that I think everyone enjoyed.
Yeah, I mean, Justice Breyer was asking a number of focused questions on the text of the Clean Air Act, but I wouldn't characterize it as hostility. He was just focusing on some of the words. Another question. This morning, a student asked me if I thought the court could issue a narrow ruling without crippling EPA. Do you see a narrow ruling, and if so, along what lines?
So, to the extent that the court reaches I assume that means a narrow ruling in favor of petitioners in this case in some way. The narrowest ruling would be to say, no, we don't. I mean, I assume that means a narrow ruling on the merits that would rule in favor of petitioners. And there is a sort of, the Clean Power Plan in establishing the best system of emission reduction, EPA looked at all sorts of ways to reduce emissions from power plants and landed on this generation shifting concept. And it involved generation shifting among sources that are regulated under Clean Air Act, under Section 111 of the Clean Air Act, so fossil fuel fired power plants, and then also generation shifting to non-emitting generators, so that they're not sources. And that is one area that's the most innovative thing that EPA did in this rulemaking, was relying on these other producers of this product that are not polluting, that they don't emit any air pollution, and so they are therefore not a source under the statute. And so I could imagine some sort of narrow ruling that they should take another look at that aspect of the Clean Power Plan.
So over the next several months, while everyone is waiting for the Supreme Court to act on this decision, what else can and should EPA be doing on climate change?
Well, I would say continue what it's doing on this rule. It is looking at it as a clean slate, as it said. It's working right now on that notice of proposed rulemaking. We have proposed methane regulations out, proposals for new and existing. We have and not, let me just expand this beyond EPA, right? We do have, it's going to take a whole of government approach. We have a commitment to a whole of government approach, and it should not wait for a decision to come down. There is plenty of work to do. And, you know, we're correctly, obviously, focusing on EPA and focusing at the federal government. But let me just say that states continue to lead the way on climate, and we need to continue to, us as lawyers and advocates, need to continue to push for climate progress at the local, state, regional, and federal, global level. So the work doesn't stop. Our deadline for it is not a court deadline. It is not a statutory deadline. It is a planetary deadline. We've got till the end of the decade. The IPCC brought that into stark relief again yesterday, to do all that we can do. And so the work continues while we wait for a decision.
I agree with all that. I would flag also the motor vehicles regulations that EPA has issued and is continuing to work on, both light duty, heavy duty. There are also more on aircraft. They can do more on ships. And so, you know, we need to be decarbonizing throughout our economy. EPA has a role in that. Other federal agencies have a role in that, and states have a role in that. And, you know, one of the things that we do as advocates is we're looking state by state and power plant by power plant. And, you know, utility commissions, even in states that have traditionally relied heavily on coal-fired power plants, are finding that, you know, it's a heavy lift to keep these plants running. They are old, they're dirty, they emit all sorts of other pollutants, and they are becoming obsolete and are obsolete in many cases. And they're passing on, in order to keep investing in these plants, ratepayers have to pay for that. And there's some really interesting information that came out in this past week leading up to the oral argument on West Virginia rates, which have skyrocketed over the past 10 to 15 years because they are trying to continue to keep these really dirty, expensive sources alive when their neighbors don't even want to do that. Kentucky and Virginia utility commissions are saying, no, we don't want our ratepayers to have to invest in these plants. So it's just, there is a lot that can be done at the state and local level, and individuals who are looking at their electric bills can see this is, you know, these plants are no longer competitive, and we need to be looking at other sources, clean sources of electricity generation.
Yeah, and Michael, I would add that, you know, and this is not inconsistent with what I was saying before about federal agencies and regulatory agencies having authority to regulate at the edge of technology and technological development, but also it's not just regulatory action. You know, I think that there is substantial amount of progress that's being made in the private sector. You know, the people are speaking. You know, the people are basically saying that we want a society that is less based on fossil fuels. We want action, and we're, you know, trying to foment action through the private sector to try to decarbonize the society, and that's just as important.
One of the most important things we need to do to fight the climate crisis is to build out just a massive amount of renewable energy to replace the coal, ultimately to replace most of the natural gas, to allow us to electrify our motor vehicle fleets and our buildings and so forth. This is mostly being done by the private sector. There are some federal subsidies that are involved, but it's mostly private companies that are wanting to build the wind and solar. And when given the opportunity, we're finding now that they're stepping up at a massive pace. Just a couple of days ago, there was an auction on offshore sites off Long Island for offshore wind, and it was raised an astonishing amount of money. There was just a tremendous interest by the private sector in building out the wind and the solar that we need, especially given both the increased demand and need for them and the plummeting cost. And so none of this depends on the Clean Air Act. The motor vehicles depend on the Clean Air Act, but parts of the Clean Air Act that are not plagued by the ambiguities we see with 111D. So EPA is moving forward with those as well. Well, we are out of time. I want to thank Joanne and Jill and Keith for a terrific discussion this afternoon. And I will now turn it back to Chandler to close us out.
Thank you so much. I just want to quickly thank our audience for joining us today and for your many thought-provoking questions. We hope you'll continue to watch this space in the years ahead, and hopefully we'll have a decision coming relatively shortly for us to discuss once again. But just want to say thank you so much to our fantastic panelists, Michael, Joanne, Keith, and Jill. This has been really, really phenomenal. Just really appreciate your time and expertise. Thank you all so much. Please take care and stay safe. Thank you all again.
Bye, everyone.